Good morning, starting it. Good morning, everybody, members of the public. We're going to start this morning with 874, bill related to self-storage businesses. And we have with us Representative Nigro from House of Commerce to introduce us for the first time to the bill. Welcome.
Thank you.
Introduce yourself and
Sure.
it's about 874.
All right. Representative Michael Nigro from House Commerce Economic Development.
And what town are you from?
Bennington.
Okay, great.
So I guess I just give you a brief overview, and then if happy to talk about anything else, however you want me to do this. But H74 is a pretty straightforward update to storage unit laws. A lot of the bill are simple stylistic changes. In terms of the substantive portions of the bill, there is some modernizing of our storage laws, self-storage laws, particularly the steps of lien enforcement, because previously there were a lot of requirements around only using certified mail and only doing lien enforcement sales in person and advertised through newspapers. And this bill allows email opt-ins to, in some instances, replace mail, online advertising for lien sales, and online sales instead of simply in person.
Can you ground us just really quickly?
Sure.
I assume self-storage is those businesses that you see on the side of the road with like little garages where you store your furniture or excess property. That's what we're talking about.
Yeah, you rent a limited small space typically. Yeah, so that's exactly right.
And has this bill been in the Commerce Committee in previous years that we
This was, yes, the House actually passed the bill very close to identical, a couple minor changes 2 years ago.
2 years ago.
Yes.
Never got to it. Okay.
As I said, along with some of that modernizing, there's some slight strengthening of disclosure requirements, a little bit of alignment with standard practice nationally, and some new protections for people's personal information, which may be in storage.
So what brought this bill forward? Were there problems out there that you heard about? Who are the main proponents of the bill? Is there a lobbyist or is there a council or something that represents these?
Yeah, primarily the advocates for self-storage units, the owners of self-storage for the buildings. Again, I think, and actually some of the changes in here, I think, are probably simply cleanup changes that should occur anyhow. But in terms of the pieces that were brought to us by the self-storage owners, some of the modernizing does fix problems surrounding kind of an antiquated system of lien enforcement sales. So selling the property of somebody's storage unit if they haven't paid their bills appropriately.
Do we have anybody from legislative council?
They went all upstairs with Senator Clarkson on S210, but they'll try to get down here.
Do you want to attempt to walk us through the bill?
Yeah,
We usually have legislative council do it, but if they're not available and you can do that, that would be great.
Sure. So I would assume it's okay to skip over the stylistic changes, right? Some new definitions. Electronic mail is a new definition because this bill would allow for use of email for certain notifications.
So I'm just looking at it very quickly when I hear that. I'm sensing that the old law may have required things by certified hard copies and stuff like that. This is bringing us into the 20th.
Yeah, exactly.
It's going to be a problem for our housing bill when I see here, you can't use the self-storage space for residential purposes.
Yeah, we should try and convert those to like mini rooms.
We've been dealing with housing.
Yeah, no, I know. There's a definition of 7 personal information, and that was added because later on there's some updates to protecting personal information in storage units.
Could you sort of flag for us? I don't mean to interrupt you, but what this is more for privacy issues and trying to make sure that you don't disclose stuff, or is the law present that you need to open it up somehow?
The primary concern is that if a storage unit renter doesn't pay and the owner has to sell the contents to satisfy a lien or part of a lien, that storage unit may contain personal information, medical records, financial records, and we wanted some protections. Wanted to be thoughtful about some protections.
So we'll get into that later.
Yes. Yeah. Moving to section, jump ahead, because like I said, a lot of this are not really substantive. Under disclosures, so it's section 3903. We did add a disclosure for security deposit, and any of the conditions for retaining or returning the deposit. Again, just thinking about robust disclosures as a consumer protection. So that was section B. It's a small change. The bigger changes for disclosures are down, and not sure we all looking at this the same way. I'm on page 5. We have the same copy, but starting at the top of page 5, it starts getting into the option for utilizing electronic mail. And one of the important aspects is it is an opt-in only. So a storage unit owner can only inform a renter of late fees or non-payment or anything revolving around the lien if that renter opts in for electronic mail notifications. If they don't, then it stays with the standard mail option.
Tell us about the lien. Sure. We can't assume anything about the level of understanding we have.
Yeah, no, I appreciate that.
Is there like a statutory lien if there's a non-payment without having any kind of filings in the land records?
Yes. Yes, there's an automatic, and this law, this language here creates that lien automatically as part of the rental agreement. Somebody rents the unit, there is an immediate lien on the possessions if there are any,
What's the status now? This was presented as a consumer protection bill. It sounds like that may go in the other direction.
Well, I guess I would say, as I said, a lot of the folks that brought it to us were the self-storage unit owners. So owners being owning the building versus tenants or renters renting the space, renting a unit, I should say. But I think certainly the work on this was trying to strike a balance between the needs of the owners and tenants.
I'm not prejudging that fact at all. I think that's so what happens now when someone doesn't pay? What happens to that property?
So in terms of the lien, the process is very much the same right now. So right now, and I have to tell you off the top of my head, I couldn't tell you the time frames. They're all contained in here. But if somebody has not paid their rent on the storage space,
Right.
after a certain amount of time, the owner of the storage facility has to send a notice of non-payment by mail.
Right.
Then after a certain additional amount of time, they have to send a second notice by certified mail.
Okay.
And then it starts shifting towards a lien sale. So then they have to start making notice that, again, if they do not pay their fees, that the contents of their unit will be sold to satisfy the lien.
So is a lien created after the second notice in statute by law?
I think, you know what, that's one I don't want to answer unless I can find it specifically or have David Hall answer that. Because I don't want to say the wrong thing. I think the lien is created.
But there is a lien, somewhere in the process, the present statute creates a lien
Yes.
on the property in the non-paid units, non-paid unit.
So yeah, I think I can actually probably find that just a moment. I think there's a section.
So are we changing that at all, or just allowing? it to
So
be done
there
by
is no change to that, and in fact, so I'm going forward to page 6, and there's the subsection, the section on liens. And the first line creates a lien, and an owner has a possessory lien on all personal property located in the storage space. And then breaks down conditions to that. The lien is created as of the date that the storage unit, an occupant stores personal property in the storage unit. So as soon as they store, it's created.
Yeah.
I had a question. Is the lien removed after they've after they've sold all the property and
Yes.
disposed of everything?
Yes, there's no lien beyond the simple contents of the storage unit.
Okay.
It doesn't, I mean, it's not like that's put on a house for non-payment to a contractor or something like that, because that has to be reported. So this just is, how does it happen, a right, such an enforcement section. I'm understanding existing law automatically creates this lien that gives the owner of the unit, not the property. Business person gives them a lien if they go ahead and sell the property. And if they ever get sued, they can pull back to the statute and say, I have a right to sue.
Yes, and it's very clearly stated right at the end of the bill that they have no liability if they follow the steps of the lien sale process. They have no liability for any of the contents that they sold.
And that's after 51 days?
Did you raise that liability that says the flag up to the judiciary have any comments on this at all? Because I haven't read the section, but when people raise immunity, sometimes they sweep in more than they want. So follow the steps, but in following the steps, it could be negligent or something like that, something that people didn't even account for. So we want to make sure that we're not extending immunity to more than we need to. So did they look at it? Didn't they?
I don't believe that they looked at it.
Okay.
Sorry.
Okay, this is the way we sort of operate here. Supposed to going through the whole thing.
Oh,
Letting you
that's,
talk, we try to clarify things as we go.
that's
So,
fine.
so you can pick up wherever you want to, I guess.
Yeah, so I think it's on page 5. There's a new language allowing the rental agreement to place a property value limit on the storage space, which would be the maximum liability of the storage unit owner if anything was supposed to happen to the property in that storage unit at the property owner's fault. And that is in line with standard practice nationally. And that wasn't prohibited by current law, it just wasn't explicitly stated.
What page of line?
So that's page 5, subsection small b. So essentially, if the owner of the storage unit says you can only store $5,000 worth of property in this storage unit, if you were to store $50,000 worth of property and anything happened and it was ruined, there's a limit on the storage unit owner's liability. As long as they add that in
The agreement,
in the
is that commonplace in agreement? to
Yes.
both of it?
The late fee, again, previously late fees were allowed, were not explicitly allowed, but it was something that prohibited late fees. This does put a cap on what late fees are, and the cap that is used here, this is the next section, C1, is in line with the national standard.
Is this, how big of an industry are we talking about? And how many storage units?
We
How
did
many
hear-
businesses?
We did hear how many storage units, and I have to admit, I presented this bill in January, so I don't remember. I feel like it was in the ballpark of 100 storage units, facilities.
Facilities.
Yeah. But yeah, I can't swear to the exact number. Again, get into a lot of substantive changes.
There was no restriction on late fees prior to this
Yeah,
existing now?
yeah, there was no actual clarity around late fees, so there was nothing in law about late fees. And again, this just simply puts a cap on it. So then, section 3904 gets into the details of the lien. And actually, I don't think there's any major changes there. The next section, enforcement of the lien, 3905 on page 6, going through 7. And,
Question before you get to that, go back to the late fee for a second. How did you come up with the amount of a late fee to charge? As to whether or not, for example, it's a reasonable fee?
there was some conversation around that, and the testimony that we had taken that this is has kind of become a standard nationally. That we had the exact number of states that have used this, but it's a fair number of states that have
What,
used
for example, is there any average or guideline of what the rental space rents for?
There are.
I mean, I know they're various
standards.
sizes.
Yeah, they, again, there's a range, and depending on the area they're in, there's certainly a range. We did hear a little bit on that, oftentimes they can start it as low as $50 a month for a small section, go up to several $100s a month.
So if you have something that's $100 a month and you charge 20%, then you got $20, which is your base fee, and whichever's the higher. If you got $200 a month, you can charge a $40 late fee. And the late fee kick in is for each period. I know you send a notice out at 5 days, and then you follow up, I guess, a total of 15 days from the beginning, as I read before. So if you have a $200 a month unit, you've got a $40 late fee right off the bat. Just instinctively, that just seems a little high to me, but
Oh, no, I didn't know. I know that the credit card companies charge that.
If I could just add one point this, that we definitely heard from storage unit owners that it made a lot of sense. Once somebody has stopped paying on a storage unit,
Yeah.
oftentimes that quickly starts to look like an issue of abandonment, which is the most common situation, is that somebody simply decides their monthly rent is not worth them paying for whatever they've got in there.
Yeah.
They say, I'm just not taking it. Or the other thing that will sometimes happen is they'll say, I'm not going to continue paying on this. They'll go take any items of value out and leave the rest. So, the storage unit owners they don't really want, they're not after the fee, the late fee, they aren't after the,
They're after being able to rent
they
the
just
unit.
want to rent.
Yeah, I understand.
So, we took testimony from storage unit owners, and I have a feeling that, they would be, many of them would negotiate over a fee pretty quickly, as long as they get their rent. I think that's the priority for them. They don't want to go down the road of a legal sale.
Did you take testimony from the Attorney General's office?
We did. Yes,
And
Are they comfortable with this?
yes.
And I don't assume that you really found any consumers that were affected by this figure.
No, we did do a review of complaints because the Attorney General noted that this is not what they would consider an area of high complaints. So they have their list of common complaints. This is not one of them, but there are a certain number of complaints that come in, usually related either to disagreements over the contract or the terms, or potentially damage to something in a storage unit. The complaints were varied. There was not a clear trend of complaints that highlighted a significant area of concern.
All right, so enforcement, do you have a question?
Let's see, lien enforcement. So again, a lot of the lien enforcement doesn't change the timeframes or the way the lien is enforced to current law. So the process is the same as current law, with the exception that there's an option for email notification if somebody opts into it. And the other change is, instead of just certified mail, we've included the use of first-class mail with a send receipt. And part of the reason for that is certified mail doesn't forward to a new address if somebody has moved, even if they have registered with the post office their new address. And that's a particular problem for storage unit owners because such a high number of people use storage units when they're in the middle of a transition or moving. Adding first-class mail helps alleviate that issue. So first-class mail will forward.
So I'm more concerned with the electronic, if somebody doesn't have a computer, doesn't have email, is there a provision that somehow they still get notified?
Yes, so again, for the email or electronic notification, it's opt-in only. So when they rent the unit, if they want to stick with mail, they don't have to do anything.
Oh, this is the person who owns the property.
This is the renter of the storage unit, the tenant. They can opt in to use email, but they do not have to. And the other backup is if somebody does opt in for email, and there's emails are sent and the storage owner does not hear, they still have to send at least one certified or first-class mail notice as well. So there is still that backup of physical mail, of first-class or certified mail.
Can you get into the issue of whether the person who has this opt-in choice email, is it permissible for the landlord, the business owner, I don't know how to describe it, the storage unit owner, to insist upon an opt-in and somehow say, I'm not going to rent to you unless you check this box?
And my understanding of the language is that would not be permissible. I mean, that it's clear that, a tenant has to voluntarily opt in. So I think if a storage unit owner was to do that, that wouldn't be in compliance with this. So again, the process remains the same here. First notice of default, second notice of default. The timelines and the days between all those remain the same as current law. The only change to this section is adding first-class mail as an option or electronic mail if they've opted in. There are some interesting definitions. There's some noteworthy definitions around delivery and what qualifies as delivery. So we certainly have some questions on, for instance, an email. What counts as? I mean, how do you show that you have delivered an email? How does a storage unit owner verify that? Apparently, there are services that are commonly used by storage unit owners in other states and could be used by Vermont storage unit owners that basically create a receipt for having sent the email to a valid email address.
Just going back to the Attorney General, you said, it sounds really appropriate that you consulted with the HQ and effectively said the problems that sort of vary. Were there examples of overzealous storage unit folks that sold the property without the knowledge of the individual to get their furniture or get some compensation back or something?
As I said, it was the number of complaints that we were given a list of. I think there may have been one or two that said, hey, we thought that our stuff was inappropriately sold. Nothing that that the Attorney General saw that as a concern, an area of concern, or any sort of common problem. Again, just speaking to the reality of how this works in practice, oftentimes the storage unit owners are slower to sell items that they are allowed to be even in this process.
Yeah.
And part of the reason for that is oftentimes they don't succeed in selling it and they end up paying to get it out of there. So for them, the absolute best option is always for the occupant to come and get their stuff or pay their to pay for them.
Right.
So didn't we pass a self-storage bill last year or 2 years ago?
2 years at the House did, I can't remember.
Because remember, it's Alice Nitka's bill. Oh,
I can't
anyway, this is what we're doing this.
It did pass the House, but
I can't remember why.
I feel like we have gone to,
all right, now I just need to find my place for a moment here.
so hot, so excited.
I am sorry, I was momentarily lost. So it moves into, after the notice section starts moving into the actual sale of property to satisfy a lien.
What page?
That's the part I'm working on.
I think we're up to page 10.
On page,
That's what comes after the notification.
your sale is at the top of page 11. It says sale. It's all crossed out for it. An owner that fulfills the notice and advertisement requirements of this section, is that what you're looking for?
Yeah, well, I'm sorry, which page?
Page 11, top of the page.
Okay.
There's notice,
Yes.
section
okay.
5, delivery Michael identified
Right.
on page 10.
So some of the changes made to the actual sale are, first of all, the current law only permits the sale to be advertised in newspaper, and that has been problematic, as a lot of local newspapers have ceased to exist and readership has gone down. So there is a option added. You can still use newspaper, but there's now an option for advertising a sale of lien, sale of property satisfied lien over the internet. And I'm looking for the exact language, which
On the internet?
yeah, it basically requires that a
Well, you have to,
commercially reasonable manner. There it is. Okay, so actually that was, we went a little past this. It's page 9, bottom of page 9. So to advertise the sale online, a owner of the storage unit has to use a commercially reasonable manner. So we certainly asked questions around what that meant, both legally and in practice. Legally, it's like baseball on common term. In terms of practice, what that probably means is there are several websites that are specifically geared towards sale of storage unit items. Someone had referenced the fact there's a TV show about storage unit sales, and so yes,
does it come to this?
I'm afraid it has.
Find that entertaining.
Yes, I'm sorry. I'm sorry to say. Anyhow, we looked at some of these websites, and that would be a good example of a commercially reasonable manner. And as a way of kind of measuring this, and again, this was another area there's some conversation around, but a manner of advertisement is considered commercially reasonable if 3 or more independent bidders attend or view the sale. And the online sales, these platforms that storage unit owners use for these lien sales do have a way of recording how many people have viewed this, how many people have made a bid on it. And so that was kind of the measure for this section. Again, look, speaking kind of to where that comes from, that was a conversation that was a little tricky. Sorry. But realistically, we recognize that there is no certainty that newspaper advertisements are seen by anybody technically. And so we thought this was a reasonable measure.
Okay, so we're gonna have to move along, sorry to say.
That's fine.
Wrap up in a couple of minutes, that'd be great.
So I'll just maybe skip then to the personal information piece. So at the bottom of page 12, if the storage unit owner who's selling property satisfied a lien has a reasonable belief that the storage space contains personal information, they, along with notifying the tenant that, hey, there's personal information in here, they cannot knowingly sell any personal information. They have to destroy any personal information. And they also, if somebody buys the contents of the storage unit, they have to confirm with the storage unit owner that whoever wins that auction has to confirm, if we find personal information in the contents we purchased, we'll return it to you so you can destroy it. To the owner of the storage unit who has sold the property, yes. And the only other significant area is around towing. Previously, a vehicle that may be kept in a storage facility would be treated the same as any other property. However, the sale of vehicles is captured in other areas of law in terms of what case to be done with title for abandoned vehicles. So this change really defers to that. So instead of the storage unit owner trying to sell a vehicle themselves, after their notice period has ended, they simply have the vehicle towed, and a towing company, which more appropriately deals with that kind of sale anyhow, then becomes responsible for the sale of a vehicle.
Thank you, it's a very thorough review. Appreciate you coming in. I think we got a handle on it. We'll hear from the state council as we move forward.
Thank you.
Sounds good, thank you.
Well done.
Thanks.
Representative Stevens, sorry to keep you waiting. I'm sure the best order to go, but I know your time is valuable, so why don't you give us a brief introduction? This bill is H477.
H477, sure. Good morning, everybody.
Good morning.
Representative Tom Stevens from Waterbury, representing the Washington District, Washington Chicken District. And H477 is a, on one hand, it's a technical correction, but it's more than that. I mean, it's a very small change in language, but several years ago, we passed the crime victim leave bill. And that was something that was pretty powerful to just realize that crime victims didn't have the right to take leave when they were dealing with issues, dealing with the judicial system or other systems, and dealing with the outcomes of the crime that was perpetrated against them. I received a phone call from our attorney last year who shared his story about how he came upon the need to change this, which is essentially saying that if a crime is committed against someone and there's a long process to get to that person, the alleged criminal, to get sentenced and be a criminal in this case haven't committed this crime. Our court systems basically say they're alleged, so they're innocent until proven guilty, and so the whole aspect of that person upon whom the crime was committed is a victim of an alleged crime.
Right.
And so there's a loophole. There was a loophole there in terms of how somebody might interpret that standing. So this bill changes that, corrects that. So it's again, on one hand, it might be a technical change, but it's a huge substantive change.
What is it back to the date up to?
What's that?
What does it back the date up to the date of arraignment or?
I'll let Damien deal with the details on that right now. But this is we think that this closes the loop on what we were seeking to do. It expands the definition of family member or like who could take this leave in their relation to crime victims. And I will just highlight, and again, I'll ask Damien to take you through it. There was a case of someone we know who works for the state who had to deal with this situation and asked us to change. Another small change is in H713, and I'll have Damien will explain what it is. We couldn't take it on for this bill, but it has to do with the definition of what that crime could be, and that's just something to consider if you move forward with this bill.
So I see on the title, it looks like, does this extend this protection to people who are filing relief from abuse orders?
Yes.
That was already an existing statute.
Okay.
So it's just updating the title to reflect that reality. So I'll walk you through that.
Okay.
So this bill passed unanimously out of our committee. I believe it passed unanimously by voice vote on the floor. It was, again, it was one of those situations where we felt we did the right thing several years ago, and now we need to do the correct right thing.
So essentially, we're changing the definition of when somebody is considered a victim of abuse or a victim of a crime.
That they were creating the period
Right.
so that during the period where it's alleged,
Right.
that they have the protections that we sought them to have, right?
But and those protections are that you can't be, you can take time off, but you can't be fired, and you can't be
Yeah,
fired.
you have to be granted leave in order to,
Or it's not paid for.
no, not necessarily. Again, that's an employer option, but it has to protect, this is a job protection.
Yeah.
Person could use a personal day, they could use a vacation day if they had to, if they felt they need. I mean, it's open to, but this aligns with our current, or adds to our current unpaid leave.
And we'll ask David this question, but is it open-ended? So if the alleged crime is going on in the alleged state status for 2 years, you still have the right to get your job back?
Well, I think it's not so much to get your job back as much as it's not about the recovery period if you were a victim of abuse. That's a different situation. This is if my wife was or if I was involved in a crime and I needed to go to court, I needed to show up in court, I needed to have a doctor's appointment. I had
This is what we did.
Okay,
yes.
This is
okay, I thought it was for protection because
No,
you didn't want to be fouled at your job or something, but okay, got it.
No, it's about
It's about keeping your job when the period is still alleged and not.
But when you are a victim of a crime,
Right.
when you need to take the time during business
Got it.
hours.
Got it, okay.
Is there
Thank
any
you very much.
limitation on the amount of time that could be taken?
no, but it is limited to criminal proceedings. So, or to getting a relief from abuse order. So
Oh,
the
so
limitation is
Okay.
by nature of the way the court proceedings work.
You're welcome to stay, Representative. Stewart.
I need to go sit on my bottom for the next 6 or 7
Somewhere
hours,
else.
so, yeah.
I
So
gotta-
I'll switch, are you good with me?
Yeah, I can ask Damien.
Okay,
Thank you.
thank you. Thank you. Yeah, I just want to say I came down here 2 minutes before I left, I was like, oh, this is gonna be about some other bill that's. But one of my committee mates said, no, it's about this bill this week.
Yes, because I thought you told me you were coming down on another bill.
Yeah.
Anyway, thank you for hearing me out on
You
210.
bet.
So before I get into the bill, it probably makes sense to show you the current law so you can understand why the current law is problematic. And then we can talk about what the bill does.
Can I ask my question so I can
Sure.
fully understand the comparison? I mean, so number one, if you get a relief from abuse order or a stalking order, those can happen outside of criminal court. So as you know, they're not always called victims of crime. When you go to get relief from stalking or abuse, it starts with the police station, then can advance to court for a temporary order, or they can do, it doesn't have to start at a police station. It can start at the police station or at court. Then you have to get your temporary order at court. Then you go in for your final order, which is often half a day to a day. So I'm just looking at this and trying to make sure embedded in the law is all the components of what you need to do.
So the existing law already allows an employee to take unpaid leave, guarantees the right to unpaid leave, and then at the employee's option, they can use any accrued leave that they have during this time. But it guarantees unpaid leave already for a relief from abuse hearing, a hearing concerning an order against stalking or sexual assault, or a relief from abuse, neglect, or exploitation hearing under Title 33, which is a vulnerable adult. And these are all in the instance when the employee is seeking the order as the plaintiff. So our existing law already guarantees that, and this doesn't change that, except to just recognize that that's part of the existing law in the title. So when this started out, I think this was 2017 that we passed this originally. It started out as just crime victims, and then the bill, as often happens here, changed, but I never updated the title to the section. So this is just correcting that error. But the current law, the issue with the current law, and this was actually identified by Senator,
Judiciary.
Senator Benning, I'm sorry, Senator Benning identified this to me this summer or this fall when we were looking at the employee policies for the steakhouse here through JLNC. And he pointed out, because of his work as a criminal defense attorney, the individual is not actually a crime victim until the end of the criminal proceeding.
Right.
And our current law says that to be an employee, you have to be a crime victim which means that you literally have to have already been adjudicated as the victim of a crime in order to take any of the leave permitted under this section, which was not the intent
Right.
of the original bill. It was to provide leave for people to go to that hearing when they're the alleged victim, or in the case of seeking a relief from abuse order or an order against stalking, when they're seeking that emergency order to get protection, and there may not have been a criminal adjudication yet. So, or even criminal charges at this point. There
So
may
the-
just
so
be,
the- So the leave is just in relation to the formal adjudication of the stalking or crime.
it's the court proceedings.
That's not for the period before you get to court.
No, it's
So
just to
here-
go to the court proceedings so that you can go for your day in court. If, you know, there are other things you may have leave rights for example, if you're recovering from an injury, you may have leave under either the sick time law or the Parental and Family Leave Act, but that's a separate issue. And that actually is what we'll talk about it with the mention of H 713 that Representative Stevens mentioned. But I'll get to that in a minute after we get through the bill, because I think to start with, but this is the problem here, is that this was prejudging the issue. And effectively what that would mean is that if this is the first time you're a victim of a crime, this law wouldn't protect you, because you would have to have already been a victim before you could take advantage of it if you follow the plain meaning, which wasn't the original intent of the law. So what the bill does, let me just pull up the bill and share it again. What the bill does here is it adds in a definition of alleged victim to start. So an alleged victim is a person who's alleged in an affidavit filed by a law enforcement official with a prosecuting attorney of competent jurisdiction, either state or federal. And you'll notice it's lowercase state. So you could be the victim of a crime in New Hampshire, New York, or Massachusetts, as long as there's a law enforcement affidavit filed with the prosecuting attorney there that is identifying you as the alleged victim. You can go to that hearing as well. So this isn't just limited to Vermont criminal court hearings. To have sustained physical, emotional, or financial injury or death as a direct result of the commission or attempted commission of a crime or act of delinquency. And then the term alleged victim also includes the family member of the person if the person is a minor, found to be incompetent, alleged to have suffered physical or emotional injury as a result of a violent crime or act of delinquency, or was killed as a result of the alleged crime or act of delinquency. So the first two are, I think, fairly self-explanatory. These are instances when our criminal justice system deems these people as not competent to represent themselves. So being a family member there, you're there to assist them during the criminal proceeding. With the third and fourth, the fourth one was reflected already in the definition of crime victim for our crime victim statute, which is what we used as the basis for this when we originally adopted it several years ago. And so that looks at, you know, if your family member was killed, that's a hearing that you may very well want to attend. And then with the physical or emotional injury, that relates to testimony that we received from Arthur Hamlin in his personal capacity, not his capacity working for DHCD, where he spoke about an instance where his child was injured in a violent home invasion. And so this was something where he talked about how important it was to be able to attend that criminal proceeding, and that the current law didn't clearly specify that, even though, you know, the injury to his child was severe and traumatic for the entire family. the law didn't clearly protect them. So the committee did decide to clarify that suffering of physical or emotional injury as a result of a violent crime or act of delinquency, and we define violent crime, was something else that could be protected here. So this would be a small expansion of the law.
So does this allow for lead time to go with the client to the police?
No, this is just related to the criminal proceeding.
Okay.
So this is, and so the committee was conscious not to try to go beyond the court proceeding
And-
issue here.
And when you say that there's some choice on the employer's part to say that they want to use accrued leave or
It's the employee's choice.
employee's choice.
Yeah, just like our other unpaid leave statutes, the employee has the option to use any accrued paid leave during this time. Yep. So family member here, we've defined, because again, that wasn't with the existing statute. The committee decided to clarify and expand the definition slightly from what it was under the existing crime victim statute. So it's a child, foster child, or stepchild, a ward who lives with the alleged victim, the spouse, domestic partner, civil union partner, sibling, grandparent, grandchild, parent or parent of the alleged victim's spouse, domestic partner, civil union partner, and then legal guardian or an individual in loco parentis, or for whom the alleged victim stands in loco parentis. So this reflects the broader definition of family member that we've looked at more recently in some of the other leave bills, and the committee decided to go with this to try to reflect instances when the individual would potentially want to be present at that hearing or need to be present at that hearing, particularly the in loco parentis.
This bill go to judiciary at all in the House?
The judiciary did not, I don't even think they did drive-by on this. I think they looked at it outside of committee and decided that they didn't need to see it. So it primarily deals with employment leave.
Right.
And doesn't actually affect these court proceedings. It's using existing judicial and criminal law to inform its definitions, but it doesn't actually affect the proceedings. So they decided they didn't need to look at it.
So I see you getting towards the end, we have a couple of minutes, but this definition of violent crime and is the existing law meant to apply just to violent crimes, or could it be?
No.
No, so the violent crime only modifies, if you look here, the alleged victim includes a family member if the individual is alleged to have suffered physical or emotional injury as a result of a violent crime or act of delinquency, or was killed as a result of an alleged crime or act of delinquency. Currently, the existing law includes in the definition of crime victim the family member when the victim was killed as a result of the alleged crime or act of delinquency.
Expands out.
So this adds in the physical or emotional injury as a result of a violent crime, which is why we had to define
So
violent
if
crime.
I was burglarized for a petty amount or something like that, I can take off paid leave. Is that right?
Yeah, so if you were burglarized,
Just myself.
just yourself, right, but if it was a violent burglary at your house,
Right.
which is the instance we heard about,
Family.
where there was a violent assault as part of the burglary. In that case, this would protect the family member's right to attend the hearing versus if it was, a burglary where, maybe you weren't home or something like that, and there was no violent crime involved.
So I guess I would ask, just out of curiosity, it seems like a good appropriate fix to meet the statutory intent. like when Senator Benning raised this, has there ever been an example where an employer used the fact that you haven't been convicted yet, so you can't take the time off?
I don't know if there has.
Okay.
I know Mr. Hamlin can talk about his own experience here, but he experienced difficulty because of the nature of his child's, the incident with his child. Both he and his wife experienced difficulty. Well, he can explain it. I don't want to paraphrase and misstate it, but the reason this was added in was because of the challenges that his family faced in relation to their child's experience and trying to get leave both to care for their child. And now because the criminal hearing is coming up, realizing that the language doesn't expressly
So
include.
the problem arose from the state of Vermont as an employer?
The problem arose from what the law protects, and I'll let him speak to
He
the
just
rest of it.
happens to be a state employee.
Yeah,
Well, yeah, but I think some employers can view the law technically. I'm just curious, it's obviously a good fix.
yeah.
Anything else, David, this year?
So, yeah, the only other changes in here is we delete the requirement that the individual be a crime victim. And so it just gets down to employee as a person who is employed for 6 months for at least an average of 20 hours a week. So extreme part-time employees or employees who are brand new aren't entitled to this leave. Their employer could provide it to them, but they're not entitled by law to it.
That's really not a substantive change.
Yeah, so it just is getting rid of the previous requirements and cleaning up the language. So the substantive change is around really the making it so it's an alleged victim, not an already adjudicated crime victim. And there's no changes apart from the title change to the relief from abuse or stalking orders, which are protected. Although the clarification of the definition prevents someone from saying, well, you're not a crime victim, so you don't have a right to go to your relief from
We
abuse
have to get
hearing.
up to the floor.
Yeah.
I appreciate you doing that thoroughly and have a